Hello, everyone. Welcome to the lecture of today. Today we will discuss about protection of human rights in armed conflict. This will be related to international public law and international human rights law and humanitarian law. So we will try to talk about the protection of human rights, especially in armed conflict, not in regular times. For briefly introducing myself, my name is Atahan Demirkol. I'm a research assistant and PhD candidate at Afyonkarahisar University, Turkey. I'm generally studying on international migration, international security, and international law. And today, as I said, I will try to discuss about the protection of human rights during the armed conflict, which is really important topic for these days because of the Russian invasion in Ukraine and claimed human rights violations. So at the end of the course, we will also try to talk about what Ukraine government can do about the claims regarding the protection of human rights and human rights violations by Russia. So I will basically turn my camera off during the presentation to make it like more convenient. Um, yes, now we can continue with the lecture. um, First of all, I would like to say that you see my email address on the presentation. You can always reach me out through my email if you have any questions or if you have any comments or if you think that I missed something in the lecture or presentation. And if you would like to warn me about like some wrong conclusions, or if you have any questions or if you would like to discuss something, you can always reach me out. I will be happy to answer you. Okay. So you see the lecture plan for today. The lecture plan basically includes the introduction part, which we will talk about some basic concepts of human rights and why do we have to protect the human rights, how do we protect, or do we have an obligation to protect human rights. We will try to understand these concepts and understand the basic concept of human rights. And while doing the introduction part, I will also have some preliminary questions for you all. I know that that's a video right now, so it's not an interactive course, but you can always pause the video to answer these questions by your own, and then try to, match your answers with my answers also. My answers are not the correct ones every time, but you can always compare it with your answers. And main goal of having the preliminary questions is that I would like to see your improvement at the end of the course regarding the same questions. So I would like you to ask the same questions at the end of the course. You can. I'm not going to ask it in the video, but you can try to answer the same questions after you complete the lecture. So after the introduction part, we will go through the human rights concept and its evolution. Uh, Basically it's the emergence of human rights concept. So we will talk about how the human rights concept emerged and how the concept was being discussed among scholars or philosophers, something like that. And then we will go through the basic first human rights documents, like the main documents in the history. We will try to go through that uh, to give you like basic information about the first documents of human rights. And after that, we will go through the human rights protection mechanisms, which are important for our lecture because we will not just talk about the human rights protection under armed conflict. We will also try to summarize the protection mechanisms during like normal times. In that section, we will go through customary international law concept And while doing that, we will also mention about use cogents and erga omnes norms, like erga omnes obligations or obligation erga omnes. And lastly, in that section, we will talk about international bodies and treaties to protect human rights, like which treaties can be referred to protection of human rights, or which international bodies or regional bodies can be referred to protection of human rights. I would like to make a disclaimer right now. There are not just international organizations and international bodies or international treaties for protection of human rights. There are also some regional ones, like regional organizations, like European organizations, like American, interstate American organizations, African organizations. But because of the scope of this lecture, I'm not going to go in details about the regional organizations. I will just try to focus on international organizations, whereas I will also mention about the regional ones. So we know that there are regional organizations to protect the human rights during armed conflict or during normal times, but the topic of this lecture mostly focuses on the international protection mechanisms of human rights and during the normal times or armed conflict. So after that introductory parts, I can say that all of these parts are introductory parts. We will go through to human rights in armed conflict section. So in that section, we will basically talk about jus in bello and jus ad bellum concepts, which are the rules for war, just war, and rules during a war. And we will talk about what is act of aggression. We will try to define the act of aggression through the international documents and through our own definitions. And then we will go through United Nations position for protection of human rights in armed conflict. And we will also talk about international human rights law and international humanitarian law, IHL, which are two different regimes. We will try to make the distinction between them. Then we will go through the humanitarian intervention concept, which is introduced by several international bodies and several times in the history for protection of human rights, human rights and fight against the violence of human rights. And we will try to summarize them. And we will also talking about the responsibility to protect concept, which is the new one when it compared to humanitarian intervention. And lastly, I would like to make my remarks about humanitarian sanctions. So humanitarian sanction concept is not in existent literature right now, but with all my respect, that's my definition for some sanctions towards regular citizens or regular people while looking for the Russian invasion in Ukraine. We see some sanctions against Russian people, not just like economic sanctions for the country, but we see some sanctions against ordinary people. So I'll try to introduce this concept, like humanitarian sanctions, making a distinction between humanitarian intervention concept of the West, and I'll try to explain it to the literature. I'm actually thinking about writing some introductory articles or work papers related to that topic, but we will see. So as you can imagine, I have some outcomes of the lecture. So my expectation is that the lecture will help you to gain some improvements, like have some improvements in your opinion about international human rights law, humanitarian law, or human rights protection during armed conflict. So there are basically 5 outcomes of the lecture that are my expectations. So the first one is that it's about gaining the basic information about what human rights are. So I assume that you know some basic information about the human rights, like what's the concept, what does it include, or what does it have. You should have some ideas about that information, that topic. But at the end of the course, my aim is that making you clear about the like crystal clear about the what human rights are. And for the second one, um, I also aim to you to understand the concept of human rights and its development. So we will also try to look in historical periods to understand how the human rights concept has been evolved, has evolved. So we have to understand that it's an evolutionary process and it's a development. It starts with human rights philosophy, and then it goes with the nation states to the international human rights concept. And especially with the 20th century, it goes to international human rights law. So we have to see we have to see this timeline like clearer. For the third one, I also aim to uh, provide you a brief information about the milestones for human rights. As I mentioned, uh, like a couple of seconds, there are some milestones like ancient times for the philosophy of human rights, then 16th or 17th centuries for the human rights law concept. Then it becomes the international human rights law with the establishment of nation states. And then after the 20th century, during the 20th century, especially after the Second World War, it became an international human rights law concept. Like we have to have this information for a timeline of evolving the concept. And then I will I would like you to introduce main bodies for human rights protection. So my aim is that you will know some at least basic information about the human rights bodies for the protection of human rights. And finally, you will learn the terminology related to human rights law, like jus cogens erga omnes rules or norms or obligations, and jus in bello, jus ad bellum, like these concepts. You'll be familiar after the course, after the lecture. So these are my general aims. So I would like to start with some basic questions, like preliminary questions. As I said, it's a video right now, so I don't have any option to make this course like interactive with you. But you can now try to pause the video and answer each of the questions. Try to answer each of the questions. Then we can continue on that issue, like thinking about your answers. And so there are basically 4 questions. These are like kind of easy questions because I just wanted to make sure that these are not going to be hard questions for you at the beginning of the lecture. These should be like easy introductory questions, and these should be preparing you for the lecture. So the first question is that what's the concept of human rights? What do you know about human rights concept? Like what can be the human rights? That's an important question for starting the lecture, but because you have to familiar with the human rights concept, like which rights can we count as human rights, or why we can count that as human rights. These are important questions. I'm just wondering that if you have any answers. Like I wish the course was interactive, but that's the first question. So try to answer this question right now. And if you try to answer the questions, we can continue with the second one. That's about the originality of human rights concept. Like, where does it come from? Like, where does the human right concept originally come from? What's its origins? What's its origins? Like, how does it emerge? How did it emerge at the first time in the history? What was the main point for emergence of human rights concept? And there are various answers for that question. Actually, I have to say that it might be related to philosophy, might be related to natural law concept of the 17th centuries, and it might be related to nation states. Someone has some different answers for that questions. I cannot say that which one is wrong, which one is correct, but there are some various answers in the literature for the existence of human rights concept. Like, I will mention it in the lecture also. And the third question is that why is the protection of human rights is important? That's another point. Why do we have to protect human rights? What do you think about that? Like, do we have to protect human rights because they are just basic rights, or why do we believe that the human rights should be protected? Where does it come from? What happens if we, do not respect the human rights? Why do we have to respect human rights? I just want you to think about that question at the beginning of the course. Why do we do that? Like it's a taboo in the international community to talk against human rights law, right? And talk about human rights, talk about against the human rights. It's a taboo. It's not possible to talk about that. Like, if you say something against human rights, like basic rights, someone will probably or definitely say that you're not human, like, or you are disrespectful for the international norms and something like that. But where does it come from? Why do we have to protect human rights? Why it is so important? Why is it so important? So I would like you to think about that question also. And for the last question, I would like to ask the maybe the main question: who can protect the human rights? So, considering the first three questions, right now we know what the human rights are. We know where does it come from. We know why we have to protect the human rights, and the main and the essential question is that how can we protect the human rights? Who can protect the human rights? Like, try to think about two mainstream theories of international relations, like the liberalism and realism. Liberalism says that there is a hierarchy in international relations field. There are some superior mechanisms and organizations that make the international relations order like hierarchic. But on the other hand, there is also realists saying that international relations is anarchic. So there is no superior authority over any state. Like, states are the only actors that are sovereign, and they have their own mechanisms, like without any hierarchy in their relationship with other states. So, if we are in a realist world order, who can protect the human rights? I mean, what can be the superior authority, or how can it be the superior authority for international protection of international human rights? So I'm wondering your answers. You can also try to answer these questions in the comments section. So for the first part of the lecture, we will start with the human rights concept and its evolution. I can basically say that there is no certain time for emergence of the human rights concept and its evolution. Uh, in the existing literature, you will see that someone would say ancient Greece or Persian Empire or Code of Hammurabi um, for the emergence of human rights concept. And I can easily say that, like confidently say that um, there is no certain time for the emergence of human rights concept. Like for for some scholars, it's ancient Greece. For some scholars, it's Persian Empire. For some scholars, it's something else. So there is no certain time, like a universal definition of the emergence of human rights concept. There is nothing like that. And when we come like closer to our times, we see Thomas Aquinas and Marsilius, and they were important because like um, they were thinking and writing about preventing the persecution, right of resistance against the ruler, and which was really hard for that times, the freedom of religion and conscience. Like think about like uh, the Europe during like Thomas Aquinas' time and Marsilius' time, and they were uh, under the rule of the church, and they were talking about freedom of religion and conscience. That was really hard to think about, and you know, it's not relatively hard to talk about this issue today, but it was really hard at those times. So because of that, these two names are important and significant for our lecture concerning the human rights concept. And when we come closer, we see John Locke and Jean-Jacques Rousseau because of their natural law concept. Like it's the philosophical base of human rights because uh, it basically explains that there are some laws, uh, those are natural. We have those natural laws in the they are just out there. Okay, we can find them. We are not inventing these rules, but rules or laws, we are just finding them. They are just here out there, and these are uh, because of that feature, they are uh, over some other rules that are invented by people. Like natural law um, comes from it's believed that it comes from God, or it was always there out of the world, and we found these rules. We didn't invent these rules. Instead of inventing like right of uh, something else, right to life, right to liberty, right to own property. These are the natural laws for John Locke and Jean-Jacques Rousseau, and I can basically say that the natural law concept is really important for human rights concept because when you think about that, some laws are natural. They have priority against or over some other normal laws or rules. So the basic rights of the basic human rights, they just come from just being a human. Like you have these rights, you're not given these rights, you have these rights because you're a human. You're a human being, and you're born with those rights. You cannot transfer them, you cannot give up them, and no one can grant you um, these rights. You are granted by your birth. I mean that no one gave you these rights. You just earned them because you're a human. So these are the basic rights that come from just being a human. And for the human rights concept, I have to also say that it's relatively modern and political concept because these are the rights against state or against ruler. So these are the rights, human rights, these rights protect one from the ruler or from the state, like the governments, like the states, like the countries, administrations. So these are not rights or laws between individuals. These are basically rights and protection mechanisms between people and ruler, people and state. So when we look through the human rights concept and its evolution, we see that um, some documents like international treaties, we cannot say international treaties for that time. We can see some treaties, agreements like bills, declarations, um, constitutions for the human rights concept and its evolution. Um, so first we see Magna Carta that was between King John and landowners. Someone says that this is an important document for human rights concept, but for my point of view, and not just my point of view, for some scholars, uh, we believe that it's not the document for human rights concept because it was just a document between the king and landowners. So it was not regulating any human rights like like in a universal concept, like in a universal definition, rather than it was regulating the rules between or regulating the issues between king and landowners. So uh, it was a different document than human rights document. And when we go through to 17th and 18th centuries, we see the human rights doctrine right now. So the human rights doctrine started to emerge, not human rights concept, but human rights doctrine started to emerge in 17th and 18th centuries. So we see like England, America, and France during during these centuries. And in England, we see Petition of Right and Bill of Rights. And in America, we see Virginia Declaration of Rights and Constitution of the United States of America. Then we see the first 10 amendments. And for the France, we see Declaration of the Rights of the Man and of the Citizen. These are the first main documents for international human rights concept. We have to remind it. So when we come to international human rights law, we have to say that it's a different time period, different historical period than human rights concept. It's different because international human rights or human rights is different than human rights law. So in the philosophy, we see human rights like as I said, in the ancient Greece or in the Persian Empire, or at the really early periods of time, we see the human rights concept. But human rights law, especially the international human rights law, the modern international human rights law, we see that especially in 20th century after the 1945 United Nations Charter. And the regime started to be established by the UN Charter, and we see the applications at the Nuremberg and Tokyo war crimes judgments, and the one of the main documents for the international human rights law, which is also criticized. I will mention about the criticisms, but it's 1948 Universal Declaration of Human Rights. Then we see the modern documents like International Covenant on Civil and Political Rights and International Covenant on Economic, Social, and Cultural Rights. So these are the modern international human rights law documents, like milestones for modern international human rights law. And as I said, human rights is the relationship between individuals and states. So it's not the rights between or the rights claimed between individuals or between states like international law. It's international human rights law, so it's between states and individuals. Like that's why you are not granted those rights. You earn those rights because you are human. Because if the states or governments provide you these rights, they can easily take these rights back because they will say that we provided you these rights, so we are taking them back. But in the international human rights law concept, like the international human rights concept, these rights are granted to you just because you are a human. You earn these rights with your birth. That's the important point for the international human rights law. And it is believed that UN Charter constructed the international human rights law. That's why the 20th century was uh, defined as the era of human rights. So that's another important milestone for human rights concept. Um, if we talk about more talk about the international human rights law, we will see the UN Charter does not explicitly have the concept of international human rights, but it implicitly has the concept of international human rights. So that's why Universal Declaration of Human Rights was published after the UN Charter. Um, UDHR is the main document of international human rights law, but yet there are some criticisms, as I said in the previous slide. Like it's criticized because of the lack of control mechanisms, lack of coercion mechanisms, like force, power, and it's non-binding. It's just a declaration, and however, it also led to some customary international human rights law, and some of its rules or provisions become binding rules. So the criticism is basically around it's not a binding document, it's non-binding because it's a declaration, it's not an agreement, it's not a treaty, but so it doesn't provide any mechanisms for protection of international human rights. That's the criticisms, but we can always remember that it led to some customary international human rights law, and some of its provisions became the binding rules for the international human rights law. So that's the importance of Universal Declaration of Human Rights. Um, Although the international human rights law, like the main document UDHR, is a non-binding agreement, like treaty, and all states are still bounded to respect the common international human rights. Um, but there are also some criticisms against this concept because um, in the world right now we don't see the adequate level of signing agreements. Like that, most of the countries they are hesitant to sign or ratify the international human rights agreements. They don't want to get into responsibility. They don't want to take the burden or obligations. They don't want to be uh, supervised by another authority for signing these agreements for international human rights law. And even if they sign the human rights agreements or treaties, they put some reservations on these agreements. And the other criticism is that nation states the only responsible agent for human rights. But in the modern world, there are also some NGOs like multinational corporations. These should be also responsible for human rights concept. Uh, so the most of the important point, one of the important point is that um, international human rights law concept and state sovereignty. So there is a distinction between national human rights law and international human rights law. Like most of the states in their constitutions, they have the human rights definitions, and they have included the protection of human rights mechanisms in their national laws, like in their constitutions. But when it comes to international human rights, what happens? Like, could a state claim the non-intervention principle regarding the human rights? Like, talk about a country that's a party of like the Universal Declaration of Human Rights, even if it doesn't have the protection mechanism uh, or the European uh, human rights documents, like say that one of the countries is a party of the European human rights documents, and it's under the mandate of European uh, Court of Human Rights. So, could the state claim that when the European Court of Human Rights intervene their applications uh, regarding the violation of human rights, can the state claim that it is still um, violating the non-intervention principle or not? So that's one important question. For for not having that such that issue, there is a mechanism for international human rights law. You have to exhaust domestic legal procedures before you go to international mechanisms. And so in that section, or in that circumstances, the state cannot claim that the international bodies are intervening their own sovereign areas. We cannot claim that because the person has exhausted all of the domestic procedures, like legal procedures, before going to international law mechanisms regarding the international human rights law. So that's the point between international human rights law and sovereignty. And for the sovereignty concept, also we have to remind that some international human rights concepts are, I will mention it later, but they are jus cogens and erga omnes obligations. So these are obligations for the whole humanity, or for the whole world. Like they are universal concepts, and one state cannot claim that violation of these rules cannot be uh, controlled by international mechanisms like international community, because these are international, like the international community's rules, like the universal rules. Okay, I just wanted to make it clear. So when we come to human rights protection mechanisms, we see customary international human rights law, and as I said before, like just a couple seconds ago, um, there are jus cogens norms and erga omnes obligations. So customary international customary international human rights law comes from the agreements on human rights. It provides the universality of human rights, and how we can produce customary international human rights law or customary international law. There are two proponents for production of customary international law. The first one is opinio juris. The second one is state practice. Opinio juris is that a state believes that doing this action comes from um, a legal belief. So they are acting like, because they think that that's a legal or that's a lawful action. And the state practice is the second proponent of the customary international law, and there should be some certain number of states acting like that for a certain time. There's no, we cannot say that it's 5 years or 10 years or 15 countries or 20 countries, but we can generally say that there should be a majority of countries acting in the same way for a certain time. That's state practice. And they are acting in the same way because they believe that it's a law, it's a legal action. So that's the opinion juris. So when we have both of them, we create the customary international law. And when we create the international human rights law or international customary international law or customary international human rights law, we create the jus cogens and erga omnes obligations. So jus cogens norms are peremptory norms. These are like the norms you cannot discuss, you cannot stand against, you cannot criticize. Yes, you can criticize, but you cannot act against these rules. And erga omnes obligations are the obligations to the whole humanity, like the universal concept, like um, you have the obligations for the whole international community. And D'Amato criticizes that if there is really jus cogens norms, where they do come from, he's skeptic about this concept, but most of the scholars, they accept this concept, so I'm not going to go in details. So in here you see that state practice and opinio juris becomes customary law. When it comes to human rights protection, we see customary international law, as I said. It's jus cogens rules over erga omnes obligations over international law. So that, what does it mean? It means that if a rule is jus cogens or erga omnes, it's above the international law. It's above the normal rules or normal laws. So it makes these rules superior to the other ones. So if you make some international human rights concepts like customary international law concepts, these norms become superior to other norms, and this gives the universality, and this gives the protection of human rights mechanisms to international human rights law. So when we come to international bodies and treaties, we see United Nations Security Council up under the chapter 7. They can determine a threat to peace, breach of peace, or act of aggression. So these are United Nations Security Council's responsibilities. And we see United Nations Human Rights Committee. We see as the main body of the United Nations, like Office of the High Commissioner for Human Rights, OHCHR. And as I said in the beginning of the lecture, there are also some regional aspects or institutions or bodies for protection of international human rights. These are some European Court of Human Rights or the European Convention, American regional organizations or African regional organizations. We have them, but in the scope of this lecture, we are not going to go in detail about these issues. The regional organization, I just wanted to make sure that you know that there are also some regional organizations, not just international organizations. As I said, the main United Nations body is United Nations Human Rights Office of the High Commissioner, OHCHR. In that United Nations mandate, there is a procedure. It's called 150503. The 1503 procedure is for the complaints about violations of the human rights treaties or human rights concepts. So there are three main ways to make your complaint, make the complaint about human rights violations or the human rights treaties violations. The first one is that it's individual communications. The second one is state-to-state complaints, and the third one is creating the inquiries. That's an important procedure for protection of international human rights during normal times or um, violation of international human rights treaties. So the most important topic is right now. It's international human rights in armed conflict. And we will discuss about international humanitarian law and international human rights law. So far, we have discussed about international human rights law, but there is also another concept, international humanitarian law, IHL, which is widely discussed and also criticized in the doctrine or existing literature. It's still controversial issue to talk about the international humanitarian law. Before talking about international humanitarian law, we have to define the lex specialis because it is referred, it's attributed to international humanitarian law. So lex specialis is a common technique for the resolution of normative conflicts in public international law and national judicial systems. So the principle maintains that in case of conflict, specific rules should take precedence over general standards. So what does it mean? If there's a conflict and if it's an armed conflict, some rules become superior to other general rules. So that's the lex specialis. So because of the lex specialis nature, international humanitarian law becomes prevail over the general rules of international human rights law during the armed conflict, and it displaces the international human rights law during the armed conflict. So that's the relationship between international human rights law and humanitarian law. When we compare both of them, we have to remind that these are two distinct regimes. There are namely two regimes, international human rights law and international humanitarian law. For international human rights law, we can say that it applies all the time, like for the protection of life, health, and dignity of individuals. And some of the international rights law, like some of the international human rights concepts, some of the international human rights can be suspended during the armed conflict. It's still a controversial issue in the literature, but for the general difference between, or the main difference between international humanitarian law and international human rights law, that is the main difference. International human rights can be suspended during armed conflict, like partly, not the whole international human rights can be suspended, but there are some rights that can be suspended, such as right of education. Like think about that. During an armed conflict, can a state suspend the right of education or not? Just think about it. Okay. But when we come to international humanitarian law, IHL, we see that it applies only during the armed conflict. So it cannot be suspended during armed conflict. Uh, the core rights are like right to life, the prohibition of torture and inhuman punishment or treatment, the outlawing slavery or servitude, principle of legality and the non-retroactivity of the law, and the right to freedom of thought, conscience, and religion. So these rights, like the core rights, core human rights, and they cannot be suspended during armed conflict. Uh, where the IHL comes from? It comes from the Geneva and Hague Conventions. So These conventions give the lex specialis status to international humanitarian law, and the main body for controlling and supervising and implementing the rules of international humanitarian law is the ICRC, the International Committee of the Red Cross. So when we talk about the armed conflict, we also have to talk about Hugo Grotius. You see his picture in the slide, and the rules of war, Jus ad bellum and Jus in bello. So as we know, Grotius is one of the founders of the international law, and he proposes peaceful solutions for the conflicts. And for that, we define Jus ad bellum and Jus in bello. Jus ad bellum is the rules for outbreaking a just war. And these are like you cannot, one state cannot just start a war because they want to. There should be some self-defense or a just reason for starting the war. It's not just starting the war because of they want to. And when you start the just war, you also have to follow the rules Jus in bello, like the just war rules, not just not for outbreaking of war, but during the just war, you have to follow some rules to keep the just status of the war. So what are these rules? Like not hitting the civilians, not hitting the religious buildings or hospitals or civilian buildings or civilians. These are the Jus in bello rules. What's an act of aggression? That's apart from the UN Charter. So the UN Charter aims at maintaining international peace and security, and prevention of and removal of threats to peace, and suppression of acts of aggression or other branches of the breaches of the peace, and conformity with the principles of justice and international law, and solving the international disputes which might lead to breach of the peace. So an action against these concepts is act of aggression. It's act of aggression. So we can define the act of aggression as any threat or use of force towards a sovereign independent state. It might be a conquest or annexation, it might be a threat against the peace, it might be use of force, it might be territorial against territorial integrity norm, which is the norm for a country, for a sovereign country to maintain its territorial integrity, like controlling and preserving its all of the lands. So when we come to protection of human rights in armed conflict, when we come to protection of human rights in armed conflict, we see several mechanisms and several organizations and like conventions for the protection of human rights in armed conflict. First of all, the first one is United Nations mechanisms. Like we can see Security Council resolutions regarding the protection of human rights in armed conflict. What can Security Council do? Like they can authorize the peace forces for the humanitarian intervention, or they can create some resolutions against the use of force of a country to another country, and they can condemn the violation of human rights in armed conflict, and they can ask for immediate stop of the violation of human rights in an armed conflict. And if the Security Council mechanism doesn't work because of the P5 members, like the permanent 5 members, and there's another mechanism for the UN General Assembly. This is called as United for Peace, and General Assembly can call the general meeting uh, in times of armed conflict for peace talks, and that's called as United for Peace. And we recently have seen that United for Peace section for the Russian invasion in Ukraine. And the last United Nations mechanism is the humanitarian intervention. As I said, the Security Council can um, authorize it for preserving the international human rights in a country, or prevent the violence against international human rights concepts in armed conflict in a country. And the other important thing is Geneva Conventions. So these conventions consist of four treaties, and they were signed in 1949 and ratified by 196 countries. And these conventions are generally dealing with the basic rights of wartime prisoners, protections for the wounded and sick, and protections for the civilians and in and around a war zone, and rights and protections afforded to non-combatants. So these are the general rules for Geneva Conventions, and these are mostly the international humanitarian law. And there's another mechanism, the International Criminal Court for war crimes. We have seen it. We have seen it for several times in the history, and it's the court judges over the war crimes. That's another important protection, human rights protection mechanism for international term. And there are also some regional organizations like European, African, and American human rights organizations, and they have their own mechanisms for protecting human rights violations in armed conflict. And the last one is one of the important things. I think it's not an official mechanism for protection, but it's media and public opinion. So especially during the Syria civil war and during the Russian invasion, we have seen that using media for the creating the public opinion against the war crimes and against the violation of international human rights, like attacking civilians, attacking or bombing civilian locations like apartments, like religious buildings, like hospitals, like targeting the civilians and killing them. So we see media and public opinion as a protection of human rights mechanism in recent years. I think I would like to make it a point right now. And for the humanitarian intervention mechanism, that's one of the important mechanisms for protection of human rights, I think. The main goal of the humanitarian intervention is to end the human rights violations in a state which is not able to prevent them by their own, or they are the violators. So let's think about that. There's a country, and in that country there's a civil war, and the state or the government is not able to fight against the rebellions or fight against the terrorist groups that are violating the human rights. There might be humanitarian intervention then. Or like in the Syria case, we see that a government is the violator against the human rights, basic human rights of the people, like killing the civilians, targeting them, or causing the persecution of them. And in that circumstances, we see the humanitarian intervention is possible against the state because it's not able to provide the basic human rights to its own people, not just for citizens, but its own people, it's for its people. So there might be threat or use of force for the humanitarian intervention mechanism. and it should be motivated by humanitarian concerns. Like it's not a military operation. It should be uh, aiming to end the human rights violations in a country. And there's also some criticisms against humanitarian intervention mechanism, which are mainly about the concerning state sovereignty and territorial integrity. Now, some scholars say that the humanitarian intervention mechanism is an imperial and um, and a colonial way to settle in a country, like stating that they are violating human rights. So we are conducting a military operation there, and we are gonna go in that country. So basically, for some scholars, give the keys of the country for the other military forces. So that's the criticism against humanitarian intervention mechanism. And we also have to say that it's an old concept, but it has been increasing in 20th century, especially after the Cold War era. We see some important humanitarian interventions in the history, like 1994, the Rwanda. It was UNAMIR operation, and in 2011, the Libya, NATO with authorized UN Security Council resolution, and 1999 Kosovo intervention was controversial in the international law field, and also in the doctrine, because it was without the authorization by United Nations Security Council. So, but we still have to remind that there was a lot of people, like thousands of people, were killing in the civil war, and it was kind of necessary to take actions against the human rights violations. So, but it was still unauthorized intervention by NATO. So after the humanitarian intervention concept, we have seen a new concept, it's R2P, responsibility to protect, because it's the term coined because of mostly the criticisms against humanitarian intervention concerning the state sovereignty and territorial integrity. So RTP concept is it, it, it depends on the name of a report produced in 2001. The report was produced by the Canadian International Commission on Intervention and State Sovereignty, ICIS, and it was also a response to Kofi Annan's call for when to intervene a country. Like when we can intervene a country, we have to define it. He said that the rules and the ways should be determined. And the main motivation point of R2P is that the states are responsible to protect their people. And when they fail, the international community is responsible for that. It's a basic concept. Like human rights is like use Kogan's norms, and there are erga omnes obligations for the whole community, for the whole international community, and the state is the main responsible actor for protecting their people in terms of their human rights concepts, like the basic rights, right to life, or freedom of fear, or something like that. When they fail to provide these rights, or when they fail to protect the human rights in a country, like when the states fail to protect the human rights in the country, then international community is responsible for protecting the human rights, because it's a universal and international concept. So responsibility to protect concept is kind of new concept, which was derived because of the concerns of humanitarian intervention, because it was still an intervention. The term intervention has a negative meaning for some reasons, but responsibility to protect has a positive meaning, stating that it's a responsibility instead of conducting a military operation. It's just a responsibility an international responsibility to protect the human rights, like basic human rights in a country, for all of the people having problems like persecution or life threats or use of force or of the act of aggression against them. So R2P concept is important in that terms. So I would like to also talk about the recent issue. As we all know, as of now, the recent issue is the Russian invasion to Ukraine. What should we know regarding the human rights now when we consider the Russian invasion to Ukraine? Or we have to start with that: is it an invasion, or why do we call that as invasion? So we call it as an invasion because it's act of aggression. It's against the UN Charter, and it's a military operation in another independent democratic country, and there was no reason for that. Like there was no use of force or threat, like the military threat against Russia by Ukraine. Not We have to focus on highlight that there was no threat by Ukraine against Russia, like a military threat or use of force. And so the Russian government decided to invade the country with military troops, and that's completely an invasion, and that's completely illegal when we consider the international law, like the UN Charter or some other related conventions or treaties, and that's basic example for act of aggression. So we can say that it's against the rule of jus ad bellum. Why it is against the rule of jus ad bellum is that it's act of aggression, as I said, because it's without two exceptions. For the act of aggression, there are two exceptions, like UN Security Council Charter 7 authorization or self-defense. The Charter authorization comes from maintaining peace, and in the cases of breach of peace. And the other one is self-defense. Like if some country attacks the other one, you have the right to self-defense, so you can conduct military operations in another country, or it's not going to be an invasion, it's going to be an military operation instead of that. But the Russian example is, it's clear, crystal clear, that it's against the rule of jus ad bellum and it's act of aggression. And we also have to know that it's also against the rule of jus in bello, because the civilians are also under attack. So we have seen lots of footage showing that civilians and civilian buildings, like government buildings, like some civilian apartments, like locations, neighborhoods, are under attack by the Russian forces. So it means that civilians are also under attack. So it's clearly against the rule of jus in bello. And I also would like to say that what could the Ukraine government do right now? So there is a locked mechanism of Security Council because of P5 system. What is the P5 system? It's the permanent five countries, like we all know that, these five countries. And the locked mechanism because of the P5 system comes from Russia, is one of the P5 countries. So they will definitely block any condemnations against the invasion against Ukraine. So the mechanism is not working in that case. But there is another mechanism that Ukraine has used also. It's Uniting for Peace, and at the times when the Security Council is not working effectively against human rights violations and territorial integrity norm violations, the General Assembly also called for a session called as Uniting for Peace, and they did that. And there is also another mechanism that Ukraine should follow and apply: the International Criminal Court in Hague. was founded by Rome Statute in 1998, and it's generally has a judgment over war crimes, crimes against humanity, and genocide. So we haven't seen any genocide crime in that issue, but we have seen war crimes like civilian attacks and crimes against humanity, like attacking on the evacuation roads, like the people evacuating from Kiev and Irpin. We have seen these footages for a long time, and for in several footages we have seen that. So for my last point, I also would like to make it clear that we are in the era coming from humanitarian intervention to humanitarian sanctions. So humanitarian sanction concept is not in the literature yet, nor in the doctrine. But with all my respect, I would like to introduce this concept to you to make you think about this issue. So human rights concept poses equal attitude towards all people of all nations. You know, we are all equal people, regardless of our religion, ethnic origins, and nationality, and etc. We are all equal peoples. So the sanctions against people from a certain nation is discrimination. So in the last example, we see that there are some sanctions for Russian people, not for the Russian government, like sanctioning Russian athletes, or removing Dostoevsky lectures in a university in Italy, or sanctions against Russian shop owners, or mistreatment against Russian citizens as international students in other countries, like the students in US or in Europe. They have, in some cases, like occasionally, seen some discrimination against them because they were not allowed to go into classes because they were Russians. The Dostoevsky course was removed because it was Russian, and Russian athletes were prohibited to join some events because they were Russians. So these are sanctions against humanity, like humanitarian sanctions. But in general terms, the West has been talking about humanitarian intervention rather than humanitarian sanction. So in the recent example, we see that the West has shifted its point from humanitarian intervention to humanitarian sanctions, which is a discrimination, a clear discrimination, and which is against the human rights of regular people. So we have to remind that and say that, actually. So for the conclusion part, how to protect human rights in armed conflict? Like, I would like to sum up. There are UN mechanisms like humanitarian intervention, authorized by United Nations Security Council with resolutions. And we have seen some examples for the humanitarian intervention in the history. And some of them were failed, some of them were late, some of them were successful. But there are still criticisms against the humanitarian intervention. That's why we have seen the responsibility to protect concept in the millennium, like the second millennium. It was the new concept of the millennium, and it's R2P, the responsibility to protect. It changed the intervention term in the humanitarian intervention to responsibility. So what's responsibility? It's the international community's responsibility to protect the basic human rights of people, regardless their nation, their religion, their beliefs, their ethnicity, and all of them, etc. And we also see another mechanism like UNOHCHR. That's the main body of United Nations for concerning human rights. And we also seen 1503 procedure for making complaints about international human rights violations. And there are also regional mechanisms such as European Courts of Human Rights, European Court of Human Rights. And these are not international ones, but if you are a party of these mechanisms, treaties, like founding treaties, you are also bound with these rules, and you are also controlled by or supervised by the protection mechanisms for the human rights, like the European Court of Human Rights. And there's also another mechanism, rather than being regional, it's international. It's International Criminal Court. It is mostly judging over war crimes. So states can or states may uh, make claims against war crimes at the International Criminal Court. So these are the basic three mechanisms to protect international human rights in armed conflict, or international humanitarian law is lex specialis during the during the armed conflict. And we have to remind that there's two distinct regimes: international human rights law and international humanitarian law, IHL. And IHL has the lex specialis status over international human rights law during an armed conflict. And it basically provides the uh, basic rights for prisoners, like civilians under attack, uh, or the one who are wounded or sick. And it's basically cannot be suspended during the armed conflict. Uh, when it compared to international human rights law, some human rights can be suspended, as we mentioned, but international humanitarian law cannot be suspended during the armed conflict. And these are the mechanisms for protecting international human rights in armed conflict. These are all what I would like to say. There might be a Q&A session, but as I said, that's a video, so it's not interactive session right now. So if you have any questions, you can write them down, or you can email me. You see my email address here, and I would like to answer all of these questions. And if you have any comments, like if you see that something was missed in the presentation or in my lecture, you can always let me know, and I would like to make a disclaimer about we missed these issues in the presentation. And or if you think that I interpret, or I told something like wrong, you can always let me know and notice me about your ideas and your thoughts about my lecture and the information that I provided during the lecture. So thank you all for being here and watching that video. I hope it is beneficial for you, and have a good day.